Our contention is that they have not fulfilled their obligation, as a result of which you could not fulfill your obligation, as a result of which it cannot be held that you are a defaulter. That argument perhaps will not come
I'll not go to that extent, my lord. My only to think that what is the prejudice being caused to me? Just to delineate that area, my lord.
They are acting in an arbitrary manner.
Arbitrary manner.
That is also permissible.
Permissible. But I am trying to bring my case within that prejudice thing. I know it's a very slippery.
Is it a conditional bank guarantee?
No, unconditional. I understand. It's an unconditional bank guarantee. And normally that's
we
the
will
bank.
Be completely rewriting the jurisdiction on jurisprudence on this.
And my lord, that undertaking.
That is the catch, Lord.
No.
That is the catch.
No, subject to the condition that they
my lord, we have extended it.
No, the thing is that it is extended up to 10/11/2022. If it does not do it, my learned friend went up to the 4th paragraph. What about the 5th paragraph of page 203? However, you have once again failed to discharge your material contractual obligations under the contract. Because we have seen his track record. He was supposed to complete the project in 2016.
That's right.
My lord, this is against an rejection of the prayer made for, my lord, maintaining status quo with regard to the bank guarantees given in pursuance to a tender. When we had filed a Section 9 application before the Honorable Court below, the interim order was passed in June. Thereafter, my lord, the tender was terminated. My lord, already the status quo was there. The court then considered, they filed their affidavit, considered the matter, and my lord said that nothing doing, the bank guarantees are permitted to be revoked. One, there are 2 bank guarantees, one performance guarantee.
Guarantees are permitted to be revoked.
No, my lord, invoked means invoked. What had happened is in the what exactly is it with regard to this water supply project, my lord? It's an old project, line from 2009, it's there. 2009 till 2018. From 2018, my lord, we had started distributing water. But the payments were held up, my lord. There was discussions all along.
Water where?
In South Guwahati, in western part of South Guwahati project, madam. Maligaon, that Jalukbari, Maligaon, that area, madam. Water is being supplied, the payments were not being made. On 1/9/2021, there was a discussion between the GMDA in presence of the minister. Therein, my lord, an understanding was arrived at that the payments would be cleared to the extent possible, and the GMDA would give us an amount of 9 crores. Out of which we will now, then we assured the GMD, if 9 crores is paid, we will give them, we'll buy projects for material for around 12 crores and then proceed with the work. But this did not happen, my lord. 7.7 crores were paid, but my lord, we had, because the government itself, my lord, there was some understanding, some contractors' dues were there, we had to pay, suppliers' demands were there, and all of a sudden this was done. We, my lord, instituted an arbitration application under 11.6. Both parties now have agreed to proceed for arbitration. The only thing, my lord, the names of the arbitrator was to be proposed. It should have been done today. Unfortunately, my lord, the court is not there today, so my lord, the matter got adjourned. Now, 17.58 crores, 48 crores, my lord, the invocation is for, now presently is for the performance guarantee of 17.48 crores. And we have a due receivable of around 20 plus, my lord, and the total would be around, our claim is around 131 crores, my lord. In that view of the matter, my lord, the arbitration will happen in a very short time. If your lordship can protect us till that time, thereafter, my lord, we can approach the arbitral tribunal under Section 17 and then, my lord, proceed with the matter.
Protect means in what?
That status quo with regard to invocation of the bank guarantee, madam. 17.48 crores, madam. Because of the facts and circumstances involved here, madam. And these...
Mr. Nair, the law on this subject is very well...
I understood, madam. It said that unless prejudice is shown. Madam, why my case is that even the termination order will see, my lord will see, there is a reference to an agreement of 11/9/2021. Wherein, my lord, the agreement is that they will pay us 9 crores and we will buy 12 crores. Admittedly, 9 crores was never paid. There was discussion.
No. Mr. Nair.
Lordship.
Please respond to this.
Lordship.
Whatever your claims and their claims, counter claims on merit is another matter.
Lordship.
It stands on a different foot.
Lordship.
But the judgments which are now available in public domain focuses on one aspect when it comes to bank guarantees. That it's a automatic vehicle which comes into play the moment the employer seeks invocation. And the jurisdiction of the court to interdict is very, very limited.
Limited.
That is when there is an allegation of fraud.
One. And
Something-
prejudice.
Prejudice will be there in every case.
And that's what
Nobody
Supreme
will
Court said.
say that, all right, I invoke the bank guarantee.
No.
Right.
Lordship.
So, whether you have a good case, bad case, that's another matter.
Lordship.
But what is the point in giving a bank guarantee? If in every case, the party comes to the court and says, injunct it.
My lord, my case before my lord.
In fact,
would be-
1994, 1 SSC 1 is the Magna Carta on this.
Lordship. And that has been followed subsequently in 1990. And the learned court below has also relied on a judgment, my lord, of 1997, that State Sugar Corporation, 1 SSC 568, wherein, my lord, it said, second exception to the cases where allowing encashment of an unconditional bank guarantee would result in irretrievable harm or injustice to one of the parties. Now, here my case would be, my lord, to just bring it. I know it's difficult, but to just bring it within that narrow campus. My lord, on 1-9, if my lord sees the minutes, there was a clear understanding that they will pay us our dues. There was a huge amount of dues pending. And then the subsequent agreement on 11-9 saying that they will release 9 crores, we will get 12 crores. Neither of this were fulfilled, my lord. If my lord can have that agreement, minutes of the discussion, that page 280, my lord. And 95% work was completed and the water was being supplied, my lord. See, this is serial number 2, my lord. GMDA will pay the contractor all such amounts presently due and certified. All future payments will be duly certified by the PMC and payments released by GMDA within the 7 days of receipt of certified bills from the PMC. Same from its own resources or from the fund available in the capital expenditure head. The fund paid by GMC to so-and-so will be recouped from the fund sanctioned by the central government. Then, my lord, escrow account and all, and the agreement, my lord, would find at page 266, my lord. If my lord have 266, the last whereas, my lord, and whereas certain issues developed towards slow progress of works and payments, which both parties resolved by mutual discussion on 1/9/2021 on mutually agreed terms. Hereinafter appearing, both parties have agreed to the terms and hereby mutually agree to abide by the following terms as mutually agreed between them and hereinafter appearing. So, my lord, they are admitting that the slow progress was because of non-release of funds. And then, my lord, page 267, they say, my lord, first party will make payment of rupees 9 crores to the second party to defray outstanding, upon receipt of which the second party will purchase material worth 12 crores within a period of 60 days. The second party, upon receipt of payment of 9 crores, will complete the work by May 22. And, my lord, it's on record. 7.7 was given, which we, my lord, adjusted with our suppliers. And the balance was never released. And in spite of this position, my lord, they have now proceeded and terminated the contract on 6/8/2022. And therein they refer to this, particularly to this agreement, my lord. If lordship can have that termination order, as a measure of conciliation, a supplementary agreement was executed by and between the contractor and GMD on 11/9/2021, which novated certain terms and conditions of the contract, under which you were required to maintain progress of the work in accordance with the schedule annexed to the supplementary agreement to expedite the completion of the scope of work under the contract. Under the supplementary agreement, an amount of rupees 7,70,000, 7 crores 70 lakhs was already disbursed by GMDA against the demand for so-and-so submitted by. So they also admit, my lord, that 9 crores never came to me. And that amount of 9 crores was to defray my pending payments. So naturally, my lord, I could not clear up the bills. So the things did not come to me. And this was being discussed all around. And till now, the bills have not been paid. So my receivables, my lord, it has fallen from your lordship. That's the actual position of law. Now, even if this is taken away from me, my lord, everything is now with them. And this is also good. I'll be left with nothing. The arbitration is just, it'll be, my lord, the board would be constituted anyway. Moment the bench is there, the board would be constituted.
Bench means which bench?
My lord, bench court number 2, my lord. Because on the last occasion, the parties agreed, if your lordship can have page 26, the last order. My lord, last line, page 26, 26/10/22 order. It has been submitted at the bar that the parties would have agreed to proceed for arbitration. However, they sought some time to propose the name of the arbitrator by consensus of both parties.
So you have agreed on some
So,
arbitration.
but that's what I've been instructed. My lord, some arbitrators' names have been agreed upon, my lord. So that will be placed and the arbitral tribunal would come into effect. Till that time, my lord will protect me. I'm only praying for that, my lord. Mhm. And they have now sent that letter to the bank, my lord, yesterday night. I have 24 hours till tonight, my lord, I have the time. One have been in 17.4 grades, which is the performance guarantee.
It has been invoked.
No, that the letters have gone to the bank. 24 hours is there, my lord. By tonight, the bank would be clearing it, my lord. They have sent this letter on 31/10. Received yesterday by the bank, my lord.
As it has already fallen from Lordship's mouth, when the court can interfere in this kind of issues. So I don't find any infirmity in the order which is put to challenge here. The lower court has rightly rejected their prayer. And see, Lordship, my learned friend went up to the 4th paragraph. What about the 5th paragraph of page 203? However, you have once again failed to discharge your material contractual obligations under the contract, read together with the supplementary agreement. The original agreement was of 2009. The project was to be completed in 2016, and Lordships know the plight of Gujaratians now. Only because of gammon, only because of their mismanagement, they have received a lot of additional payments also.
No, that is another matter. Today we will only strictly confine.
Unless there is an allegation of fraud,
Hmm.
the Honorable Court will not, because that is a separate agreement between the banker and the person who has taken the bank guarantee. That is the position. I can quote a judgment of 2008.
Mr. Nair,
Lordship.
Gujaratians have
it
already
is
suffered
difficult.
much.
You can convince the court if you want to address the court in more details. The reason is as follows. Fortunately, this court or I had occasions to deal with many of these matters. You see, the bank guarantee mechanism stands in a different footing than the contractual disputes.
Lordship.
It is a supervening guarantee given to the employer, which the employer can just invoke like press of a button,
Lordship.
even on wrong grounds. Even illegally and arbitrarily, it can be invoked.
Done, my lord.
Correct.
Lordship.
The only area is when it is fraudulently invoked, which results into an irretrievable or irreparable loss. Then the courts, for ends of justice, ex-debitor justice can look into the matter.
Lordship.
From the arguments you have made, your contention is that they have not fulfilled their obligation, as a result of which you could not fulfill your obligation, as a result of which it cannot be held that you are a defaulter. That argument perhaps will not
I'll
come
not
into
go to that extent, my lord. My only to think that what is the prejudice being caused to me? Just to delineate that area, my lord. They have said that I have to receive payments. They said in the discussion that they will pay me. Now, my lord, I was literally
So
bankrupt.
they are acting in an arbitrary manner.
Arbitrary
That
manner,
is also permissible.
permissible.
Yes.
But I'm trying to bring my case within that prejudice thing. I know it's a very slippery ground. But the issue is, my lord, if my lord sees the sequence of events, they have already put me into the back foot, put me behind the wall. Now, by withdrawing this also, my lord, I'll be left nowhere.
That is the idea. That is why you have been asked
And
to give a bank
lordship,
guarantee.
it's not a case that I have not done the work. 95% of the work was completed. And they novated the contract in, my lord, August, in 2021, September. There is a novation of the contract.
Is it a conditional bank guarantee?
No,
Then-
unconditional.
then
I understand. It's an unconditional bank guarantee. And normally that's
we
the
will
bank.
be completely rewriting the jurisprudence on this.
My
Because-
only prayer, my lord, was that till the arbitral tribunal comes into being. I was only praying for that, my lord. Till the arbitral tribunal comes into being, I was asking for a protection, not for a protection beyond that. Under section 17, I'll approach them. To that extent, I was seeking a liberty. I'm not saying, my lord, that my lord will prevent them for all times to come. That will not be invoked. But only till the, my lord, arbitral tribunal is constituted, which would be constituted now anytime. My lord will give me a liberty to approach that, and my lord will direct the arbitral tribunal to decide on this first before proceeding for any other matter.
That arbitral tribunal, when it will come, is another matter.
No, it's already on the anvil, my lord. It's coming. I've showed, my lord. We have agreed. Both parties have agreed. If it was not an agreement, then would have
The
been.
letter has already gone. The letter invoking the bank guarantee has already
Has already gone, my lord. That's the problem. My lord. That's the only problem I have. For one, my lord. Not for the other one. Security deposit that they have not invoked till now. But for the performance guarantee, it has gone.
Can you hold on the security deposit if the court doesn't interdict with the performance guarantee? Can you hold on with the security deposit for about 2 weeks or so?
And the
Mr. Saikia, assuming that in the performance guarantee the court does not.
It is not interfering.
Hmm.
My humble submission.
Let's also be equitable, which the government is also.
The thing is very clear, Lordship, that if suppose that the amount which was agreed to be paid in 2021, he did not raise any objections.
What I am proposing is the letter which you have written will
Yes.
not interfere with that. But insofar as the security is concerned, can you hold on for 2 weeks?
Lordship,
We'll give them 2 weeks time. In the meantime, the arbitral tribunal, etc., whatever.
Lordship.
Huh?
Lordship.
my lord will give us 4 weeks time, 2 weeks more, because my lord, the courts will have also to come, then the letters will go to the arbitrator, come back. It will take some time, my lord, because of the new
Let it be
conditions.
for 2 weeks now, Lordship. If required, Lordship may take it another
Okay.
call after 2 weeks.
2 weeks.
The invocation of bank guarantee for performance guarantee
Performance guarantee
has already been issued.
issued.
What is the amount involved?
It is, my lord, the exact amount is 17 crores 48 lakhs 50,000. It is with the Canara Bank.
And what is the
Security deposit is, my lord, same amount, 17 crores 48 lakhs 50,000. It is with, my lord, Punjab National Bank, Borivali, Bombay. Mumbai.
letter has been issued?
No, security deposit, no letter has been issued till now. It's only with regard to the performance guarantee there.
And where are the particulars of security deposit?
My lord would have the first one, performance guarantee, at page 21.
Yes.
It is extended up to 31/12/2022.
And
And the next one, my lord, particulars, my lord, will have it at 23. It is extended till 10/11/22, and we will extend it further. And my lord, that undertaking. will be taken.
That is the catch, Lordship.
No. We have,
That is the catch.
no, subject to the condition that they
Ah,
extend it.
my lord, we have extended it.
No, the thing is that it is extended up to 10/11/2022. If he does not do it, because we have seen his track record. He was supposed to complete the project in
That's
2016.
right.
It is not.
Within 3 days from today, they will extend it.
Lordship.
On that, the Lordship will pass that order. My assurance is before this order, we are not going to invoke it. But today is second. Let them do it and place the record before this honorable court on 6th.
Lordship.
All right, then we have it day after on
It is.
5th.
My lord will have it on next Wednesday by that time, because the time is there, my lord. Next Wednesday, my lord will have it. In the meantime, I'll get it extended. My lord.
All right. Wednesday.
Monday, let it be Monday, Lord.
Monday morning. My lord.
No, no,
Monday.
Wednesday.
Wednesday. I'll do it on
I
Wednesday.
may not be here, my colleague will.
I'll undertake.